Hello everyone! Today on our show, I'm going to be answering questions posted in the comments on our YouTube channel and our Facebook page, posted by viewers just like you. When we know, I'll say and I'll thank the person who asked the question. People often ask us how long their case will take, how much will it cost, and with COVID, what they can do because things in immigration have slowed down so much or closed altogether. If you have questions that I don't answer in this video, post them here. We'll do our best to get you an answer. We like to make videos like this, answering your questions more frequently, so please keep on asking, keep on posting.
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
In the past few months, we've had several people ask about different types of visas, including fiancé, visitor visas, and others. I did do a training on fiancé visas, that's a K1, that we'll link to in the comments below. As a reminder, social media is not private, so we ask that if you have private information, don't post that with your question. Don't tell immigration your status, don't tell them where you live. Send us that information by private message. These answers are general answers that can be applied to a variety of situations, but it shouldn't be considered a replacement for legal advice specific to your situation. By way of introduction, in case you don't know, I'm Andrés Mejer, I'm an immigration attorney, and I've written a book explaining the 9 common ways to obtain legal status. And if you comment below, send me the book, we can get you a copy of that if you're in the US. We'll mail you a copy. If you're outside the US, we'll send you a digital copy. I'm also an immigrant. I came to the US as a child. My family had legal status, and then because of a crooked attorney who took our money and didn't do anything, we lived here for many years without legal status. Now, today, I'm a US citizen, and my goal as your immigration attorney is to treat you like I wish my family had been treated. I want everyone I serve to be better off because they hired us. Let's get to some questions. The most common question we get asked is, where are you located? I'm flattered with the question. I'm happy to answer it. Our main offices are located in Eatontown, New Jersey. We also have offices in Lakewood, Newark, and Edison. You can also look at our website for a specific address at andresmejerlaw.com. We regularly attend interviews and immigration court hearings for clients in New York, New Jersey, and Philadelphia. And even further away if you're willing to pay for travel. We don't normally recommend it, but if you can't find an attorney that you know and trust near you, give us a call. For your removal case I'm talking about. Today, we have clients in over 15 states. Now you may be wondering, how is that possible? No, I'm not licensed in all 15 states. But I think you'll understand if I explain a little bit about immigration law in the US. Immigration law in the United States is based on federal law and policy. Therefore, you can hire an attorney who is licensed anywhere in the United States, and they can help you with your immigration case wherever you are. So I'm licensed in New York and New Jersey, but I have clients in California, Texas, Florida, you name it. Now, I always want to warn you not to hire a notario. In the US, they are not attorneys, and if they mess up your case, which they often do, you have no way to get your money back or to make them fix it. They don't have a license at risk. Attorneys do. We've also helped people outside the United States. Mexico, Spain, Portugal, Brazil, Chile, Israel, you name it, we've likely done it. What might be most important for you to know is that we provide the same quality and level of service for our clients in New Jersey as we do for our clients outside of New Jersey. We are 100% remote and can help you wherever you're at. Pratt Lee asked, and thank you for your question, if he needs an immigration attorney to deal with his immigration issue. Now, I've answered this question before in a video, and I'm happy to do so again. I'm going to put the link for that video below. It's going to go into more detail than what I'm going to tell you now, Pratt. I'll tell you, like I tell everyone, you can certainly handle your own immigration application without hiring an attorney. I know. I'm an attorney, right? And I'm telling you don't need one. But just because you don't need one doesn't mean you shouldn't have one. Keep in mind, I figured out how to get green card for my family, citizenship for myself, and for other family members before I became an attorney. And remember, our family did hire an attorney who did absolutely nothing. But I want to explain a few things that have changed since I did that for my family and for myself. My family was able to be excused for our illegal status due to policy in place at the time, thanks to the amnesty law filed by President Reagan in 1986. Now, today, there are waivers for some circumstances. Not everything, it's certainly not amnesty. And keep in mind, A waiver requires a legal argument that is much more effective to have an attorney to make that argument for you than to do it on your own. This administration has reduced your likelihood of success. They have changed policies and ensured the Department of Justice hired immigration judges whose job duties require them to deny more cases. In fact, they made it part of their employment and pay increase requirements that they deny a higher percentage of applications and hearings. Overall, the political climate for the US has made it very difficult for immigrants. The number of people able to get a green card, legal status, or asylum has been reduced drastically since 2016 when the hopefully old president came in to power. When you go to USCIS, their goal is no longer to help you gain legal status. Their goal is to deny as many people as possible. One of the ways they do this is by delaying the process and sending you requests for evidence, RFE, or a NOID, Notice of Intent to Deny. With those, you need to submit to them. If you don't respond, you're going to get denied. When we respond for clients to an RFE or a NOID, we submit it with a legal argument why their case should be approved. If you don't know to do that, well, you might get denied. Even when I have gone with clients, now I'm talking about the interviews, because increasingly there are more interviews. So even when I've gone with clients who I thought would not have any issue at all, if I had not been there, they would at least have their case delayed, if not outright denied. Let me give you an example of a story of an older couple that I helped. Now they spoke only Spanish, which is okay if you meet certain criteria. For example, if you are over 50 years old and you've had your green card for over 20 years, or you are over 55 years old and you've had your green card for over 15 years, you could do the citizenship exam in your own language. You don't need to learn English. You can, and I recommend that you do, but it's not required. So back to the elderly couple. The husband was approved to become a US citizen without any problem. And he was the one I thought would have an issue because he was deaf in 1 year, using a hearing aid in the second year, and the translator was on a speakerphone, not in person. But he did great. He had an understanding immigration officer, which is becoming rarer today. Then came the wife's turn. Now, husband was 82, wife was 78 years old. It was her turn. At first, she couldn't hear the interpreter. Now, she didn't have a hearing problem, but the phone was over 6 feet away and the speaker just wasn't working. I couldn't hear her either. The officer's response was, "I'm going to reschedule you." Now, because I'm known at the office and as an attorney, I insisted on speaking to a supervisor. He was kind enough to get another longer cord for the phone to move the phone closer to my client. Problem solved, or so I thought. Unfortunately, by the time all that got set up and the phone was working, there were no interpreters available for a couple of hours. The officer again wanted to reschedule the hearing. I again had to reach out to the supervisor. Now I gotta tell you, it's very rare to request supervisor intervention a second time on the same interview. This time the supervisor changed the immigration officer to a Spanish-speaking officer. We did the whole interview in Spanish. She was from Argentina. We had a great time, or as great a time as you can, given a citizenship interview, right? But she had a great sense of humor. We didn't need the phone at all. The interview went forward, and my client was approved. But I gotta tell you, if I wasn't there, it's very likely this couple would not have been approved that day. They likely both would have been delayed at a very minimum. So you need to ask yourself, are you willing to take that risk? This was somebody I thought would have no problem, and look at what happened. An immigration officer interviewing you usually isn't an attorney. Some are, but the most are not. They may think something is the law. They may try to apply it in such a way as to deny or delay your application. But an immigration attorney knows if this is true or not. If you have me or a member of my team, one of our attorneys, we can say to them, that is not the correct interpretation of the law. And we can ask to speak to a supervisor on your behalf and usually resolve the issue then and there. You won't know to do that because most people reasonably expect that the immigration officer will know and apply the correct law. If you are going to hire an attorney, again, I've made a video on this, but it helps to repeat. I recommend you hire an attorney who has the following qualities. He or she is experienced in immigration. Now, today that's all I do, although I do help immigrants with criminal and family law issues because it integrates with immigration. You need someone who focuses on the area of immigration law that you are most concerned with. Now, for the most part, there are three types: family-based petition, employment-based petition, or removal defense. Our office handles all three, but most of our cases are focused on family-based and removal petitions, since most of our clients do not qualify for employment-based petitions. Why does this help you? Because we get to know the judges, we know the hearing officers, we know the case law and the arguments that are going to best help you. There's a benefit to doing something over and over and over again. You need an attorney who's a member of AILA, that is American Immigration Lawyers Association. As a member of AILA, I receive frequent updates and training on immigration, and this helps me be the best representative for you, our clients. Now more than ever, the changes are coming literally every week. It's important you have someone who's on top of it. If you have something more intense than an application or interview, say you're in removal proceedings, which means you could be deported, I 100% recommend you hire an AILA immigration attorney. In most immigration courts, the success rate is depressing. There's one in Atlanta. This particular judge approves less than 4%. That means 96% of the time, he's going to find you deported. He's going to deny your petition. The only thing that improves success rate for anyone is to have their own attorney. Now, having an attorney to advocate for you improves your success rate by almost 60% in most courts. Having an attorney is never a guarantee. And if an attorney does guarantee you success, run away, because the chances are they're lying to you. But hey, 60% chance is a whole lot better than the alternative, wouldn't you agree?